Okay, hello everybody. Welcome to the latest installment or webinar that's presented by the Husch Blackwell law firm from our Energy and Natural Resources section. I'm Chris Reeder, and I'm one of the attorneys in our Energy and Natural Resources group. So we're very happy you could attend the webinar and hope you find it of use. So before we kind of plunge into our content, let me just go briefly over some housekeeping matters. We already had a few slides just a moment ago that talk about some of those, but here's some essentials. Just to know how this platform works, if you look at the bottom of your console, there's several application items that pretty much are what you would use to interact with our presentation. Most importantly, if you have any questions during our webinar, you can submit those using the question box. And we're going to try to answer all the questions we get kind of on a live basis towards the end of our presentation. If you can't get to any, we'll try to answer those back to you individually through email later on. But the question part is really kind of an important part of our webinars, and so really would encourage you to submit those. We'll have a PDF of the slides that's going to be available in the resources folder. Continuing legal education, we have been approved for credit, and so you can report those using the looks like CEU icon at the bottom of your screen, and we'll send a certificate of attendance which has course numbers to you tomorrow, as well as a recording of our webinar. And then towards the end, we're going to submit or ask you to fill out a very short survey, and we use these survey responses when we plan our future programs that hopefully are of use to you and your activities. So really would be grateful if you could fill that out as well. All right, that's all housekeeping items. So let's now turn to private use networks and self-generation, and why are we talking about that, and why did we schedule a webinar? Well, some of you may know our firm has been putting on a series of webinars that have sort of a national focus on development challenges and opportunities for renewable energy. And so we started that last year and managed to put those on once a month, basically, and we're continuing to do so, and very gratified to find that there's a lot of interest in that. So, but we noticed that just kind of as a group, we keep getting questions from clients and from others about behind-the-meter generation, and in ERCOT that's called private use networks, as Maria and Landon will be discussing later on. Just seems like a lot of interest, a lot of articles, people calling in to ask. In conference calls and other seminar type presentations. Seems like folks are talking about that more and more for many reasons. So we thought we would just go ahead and kind of add on another webinar that's more Texas and ERCOT specific, that just kind of deals with the subject overall and get some information out there on a subject that seems like it's getting a little more attention out there in industry. So we're gonna make this presentation, and it's going to focus mainly on off-grid and microgrid and behind-the-meter type opportunities that may exist, and how to establish and maintain those. So our two presenters are other attorneys in our energy group, Maria Ficanti and Landon Lill. Hopefully you've had a chance to work with one or both of them. Landon is formerly an attorney at the Public Utility Commission, and he is now working in our energy group, focusing a good bit on regulatory requirements. He's also worked on a lot of wind and solar project transactions for drafting instruments, reviewing and negotiating interconnection agreements, and working on regulatory approvals, ancillary to transactions, but just in general helping with compliance and certification and such. Maria Ficanti, who will be our first presenter, she also has primarily devoted her practice to administrative and regulatory issues before the Public Utility Commission of Texas, and also other state commissions and ISOs as well. She's also worked quite a bit in transactional work, also on renewable energy development projects, and as of late has been working a great deal on Texas Public Information Act requests and other investigatory type requests, focusing on client rights to maintain confidentiality for sensitive information in the context of outside requests for disclosure of such information. And she also supports litigation efforts in various rate proceedings on behalf of clients. So, sorry for kind of continuing on here. Let me now turn it over to our presenters, and let me turn it to Maria.
Thank you, Chris. So as Chris mentioned, what we're here today to discuss is private use networks. And so to kick it off, we have kind of the background. What is a private use network? As Chris mentioned, ERCOT has experienced more attention to and development of private use networks or behind the meter generation in the last months and years, especially after the passage of NPRR 945. Kind of what a private use network is. That's defined by ERCOT as an electric network connected to the ERCOT transmission grid that contains load and is not directly metered by ERCOT. So that would be load that is typically netted with the internal generation. So while a PUN or private use network is interconnected to the ERCOT system, it functions largely as an island with the system that has both generation and load behind the ERCOT pooled settlement meter or the EPS meter. So a PUN can contain many different categories of resources and loads, all of which are behind that EPS meter. And ERCOT models a PUN in its system models if it contains at least 10 megawatts of generation, has more than one connection to the ERCOT grid, or provides ancillary services. So now I'm going to turn it over to Landon to kind of describe the relevant legal requirements.
Thanks, Maria. So, I have up on the screen sort of the main PURA provisions that govern behind the network arrangements. In particular, a lot of them come from PURA 31002, which is just the definition section of PURA. And inside those definitions, there are some embedded restrictions. So I'll go over just a few of them and kind of point out how they work. So, for example, the retail electric provider means a person that sells electric energy to retail customers in this state. And a retail electric provider may not own or operate generation assets. That second sentence creates some important restrictions. The first, as it says, the owner of a generation asset cannot be a retail electric provider. But the contrapositive is also true. A generation owner may not be a retail electric provider. So since a retail electric provider is anyone that sells power under that definition, the statement really means that generation owners cannot sell electricity to retail customers in this state. And that's going to sort of pose an issue that we'll have to talk about overcoming in a little bit. The next sort of relevant definition is power generation company, which means a person, including a person who owns or operates a distributed natural gas facility that generates electricity that's intended to be sold at wholesale. And then carrying on a bit in the definition, does not own a transmission or distribution facility in this state other than an essential interconnecting facility, a facility not dedicated to public use, or a facility otherwise excluded from the definition of electric utility under this section. And then sort of a related definition is that for exempt wholesale generator. As we all know, that's more of a FERC term, but PURA also mirrors the FERC definition and then has also included states that it's exclusively in the business of owning or operating all or part of a facility for generating electric energy and selling electric energy at wholesale. And then finally, probably the most important is just the definition of electric utility, which is anybody that operates pretty much anything to do with electricity at all, including production, transmission, distribution, selling electricity, all of it. But then there's a big long list of exclusions. And that exclusion list includes power generation companies, retail electric providers, exempt wholesale generators, qualifying facilities, and a bunch of other ones. But it's important to point out that if somebody that were generating power were to fall outside of the definition of a power generation company, then they would also likely fall outside of the exclusion under electric utility, which would make them a utility, which is problematic. So that's why that definition in particular is important. And there are a few other PURA provisions that are also fairly relevant. For example, PURA 35031 prohibits EWGs from selling anything other than wholesale, so no retail sales. PURA 39157 deals with the ownership of transmission and distribution facilities. And then also PURA 39105 gives municipal power companies and electric cooperatives that have not opted into retail choice the exclusive rights of service in their territory. And then finally, the last one I have up on the slide is just the generation netting for ERCOT pooled settlement meters section of the protocols. There's also some relevant stuff in section 3 of the protocols as well that we'll talk about in a bit. So now we've kind of gone over the restrictions there, let's talk about how they fit together. And we discussed how PURA 310217, the definition for a retail electric provider, prevents generation from directly selling electricity. And this is an issue if you want to have load behind the same meter as generation. The good news is there's a solution. In competitive territories, the solution is just to use an intermediating retail electric provider. Basically, the generation owner would sell power to the retail electric provider that in turn sells power to the customer. The rep could be affiliated with the power generation company, but it doesn't have to be. And then also, it could be a third-party rep, and also, frequently if they're larger customers, it could also be an option 2 rep. And this arrangement navigates those descriptions above. It doesn't result in a retail electric provider owning or operating generation assets, and it doesn't result in a generation provider making a retail sale in violation of the rep, EWG, or power generation company definitions. And then probably the greatest part about this inside of a competitive territory is that you don't need permission from the TDU to implement this arrangement. This is something that you get to do on your own. That's not the case in NOE territories. NOE just means a non-opted entity, so that's a municipal provider or a electric cooperative. And so in those territories, there's an added layer of complication. PURA 39105 gives NOEs exclusive rights of service in their territories. This means that one cannot simply use an intermediating rep, as a rep cannot provide service. So there's the problem. You can't have a rep inside of a NOE territory. So there's 2 workarounds. The first one is just to request a service area exception, and that would allow the PUN to be served by an investor-owned utility. As the PUN is a behind-the-meter creation, this is more of a paper transfer because frequently these lines are going to be privately owned. But it would require agreement from both the NOE and the investor-owned utility. And so getting that agreement will be tricky because there's not much, neither really stands to gain from the transaction. Second option is to ask the NOE to intermediate the sale between the generation and the load. Essentially, it would function like a rep in the above example. So power would be generated by the behind-the-meter generator, and it would be transferred to the distribution cooperative, who would then, all behind the meter, transfer it again to the end-use customer. And that's sort of how one would do it in a NOE territory. So now that we've discussed how that part would work, the next question is, there's a generator and there would be a load, but how are you going to connect them? Now, PURA and FERC rules likely prohibit a generator from owning transmission or distribution lines inside of a PUN beyond essential interconnection facilities. Now, there's an exception for qualified facilities that I can get to in a second. But in general, as you may recall, the definition from a power generation company states a transmission or distribution facility in the state other than essential interconnecting facilities can't be owned by them. So This means that the easiest way to set one of these up is to have the customer actually own the internal transmission or distribution equipment. Now, in a NOE area, there's also a variation. The NOE could actually own the internal PUN lines as well, so they could be owned by, say, a distribution cooperative or a municipality. And as I mentioned a second ago, there is an exception to this rule, and that's for QFs. QFs also are an exception to is able to serve its thermal host. So imagine something that's also buying steam from, say, a gas plant. It can serve electricity and steam, and it can own its own lines connecting to that customer, and it also doesn't need to use an intermediating retail electric provider. So they sort of operate, separately, and there's well-established rules for them. So, let's say that you decided you want to create a private use network. Kind of walk through the multiple steps that go along with this. The first is that you need to notify any expected changes in system, notify ERCOT of any expected changes in system topology and telemetry, and you do it to the outage scheduler as scheduler, and coordinate with and receive written notice of approval from ERCOT. And then the next step would be ERCOT would model the private use network if it contains a generation resource that's greater than 10 megawatts, or has more than one connection to the ERCOT grid, or contains a generation resource registered to provide ancillary services. ERCOT can ask for additional information if it needs to, as it tries to make the modeling work. The third requirement is that the private use network still has to meet the voltage support requirements set forth in the nodal protocols. Specifically, I think it's 315.2. And then finally, one would submit a declaration of private use network net generation capacity availability, and that again helps ERCOT with its modeling. And I think that's then once you have all this set up, the question would then become, all right, so how does ERCOT treat it? And so the way that ERCOT actually settles load or settles generation is that it does it based on each interval. And it nets the generation and the load. So imagine there's an interval where there's more generation than load, then ERCOT will settle the whole meter as net generation. And if it's vice versa, then it would be settled as load. And over to you, Maria.
Thanks, Landon. So as you're kind of listening to this, you might think about what the benefits of a behind-the-meter resource actually are. So the slide that's currently before you right now lists 5 benefits that we've identified. So this would include reliable and secure generation resource. It can cut the carbon footprint of the off-taker, generation netting to reduce exposure to non-bypassable charges. It can take advantage of high energy prices and reduce peak demand. So I'm going to kind of unpack some of this for you. So generation netting features allow loads to reduce their exposure to transmission and distribution service providers' non-bypassable charges. That would include their allocated transmission cost of service. Specifically, it allows large loads the opportunity to reduce their exposure to the transmission costs, which are allocated based on the customer's demand at the time of peak ERCOT system demand by becoming net generation, kind of as Landon just described, or at least reducing their net load position during such peak demand events. So basically, this benefit is if you have generation behind the meter, if that generation was not behind the meter, they would be fully exposed to kind of full transmission costs. But by being behind the meter, they can offset basically what they take from ERCOT through what they're taking from the behind the meter generation. So that has been seen from a lot of kind of our clients asking questions as a huge net benefit. So then the next one is, it can be built, you would have a built-in off-taker with a potential for a financial partnership. So this is a benefit, especially in areas of high congestion. it can make a facility appear to be more profitable, or in fact make the facility more profitable. So that would be an instance if the kind of network is behind a point of high congestion on the ERCOT system. Instead of that resource having to kind of fight that congestion to deliver power, they can just, send that power to the off-taker that is also behind that same meter. So you have this built-in off-taker, especially if the off-taker has pretty consistent load and pretty consistent demand, then it can be an arrangement where, the resource knows, how much of its power is going to that off-taker and price it accordingly to kind of avoid any congestion. On the flip side of that as well, there can be arrangements that we've seen whereby the generation resource and the off-taker have an arrangement where if ERCOT prices kind of hit a certain number, then the off-taker will kind of ramp down their demand so that the generation resource can participate in the real-time market with those higher prices. So it's kind of a way for both the off-taker and the generation resource to kind of take advantage of pricing in the area. So another benefit that's listed on this slide is it affords the load a reliable and secure generation source, not dependent on the ERCOT system or vulnerable to broader potential outages. This one has become more of a benefit after, the recent winter storm where, off-takers are trying to find resources or arrangements whereby they could have potentially avoided being taken offline during the winter event, and kind of on the flip side, resources that could have taken advantage of higher pricing, kind of as I just previously discussed. Another benefit, more for the off-taker, is that they can use the behind the meter resource to kind of advertise how they've cut their carbon footprint, so that it's more good consumer goodwill. They can actually be linked to a specific generation resource, either solar, wind, what have you, that they can point to in advertising, things like that. So now I'm going to turn it over again to Landon to discuss who can participate.
Thanks, Brian. So it's pretty wide open as to who can participate in one of these arrangements. So very clearly, you can have generation resources that are connected. And we've seen a lot of those, whether they're solar or wind, or whether they're a more traditional natural gas facility. And whenever, as Maria mentioned, or I mentioned earlier too, whenever it's net generation, they'll be submitting a bid just like a regular generation resource. Similarly, settlement-only resources can also participate in the same manner, and so can energy storage resources. And on the other side, you can have traditional load, whether it's just an off-taker that's got it's just using the power from the co-located generation. Additionally, you can have controllable load resources and non-controllable load resources. So these are ones that are using their load profile and turning it off during peak times in order to participate in the ERCOT market. Now, the catch is you can't have both sides participating at once. If the private use network is net load, then you can only have the load resource participating. Simultaneously, a generation resource cannot be scheduling and selling power. On the flip side, when it's net generation and when it's putting power onto the grid, ERCOT's not going to pay to be turning off a load resource at the same time because it only sees that one meter. So I think that's a very important distinction when you're looking at that. Additionally, and then back to you, Maria.
Thanks, Landon. So one kind of or the next slide is really about the future, the prospects and expected developments. So we kind of mentioned at the beginning of this presentation, we've seen a lot of interest in establishing these networks, over kind of the past year, but really in the past few months. And that kind of goes back to the idea that with the ERCOT protocol change, many market participants think that there are more benefits to establishing these networks, and that's going to stem from the factors making them more attractive in today's economy. So kind of as this slide demonstrates, it kind of goes back to what the benefits are, but also kind of what we have seen actually expressed by clients as why these networks are being established and where they think that they will head to in the future. So again, the customer has an interest in avoiding or mitigating their transmission costs and installing a firm generation source not dependent on the ERCOT system or is vulnerable to the system for like weather events or cyber threats. They can also directly associate with the renewable resource, and again, that can be positive from a corporate responsibility policy standpoint. Again, a benefit that we have seen more and more generation resources point to is that they can realize a financial and revenue objective through the partnership. So kind of going back to what we discussed, there can be arrangements, if the off-taker and the generation resource kind of come together and, navigate the kind of arrangement to make sure that it can be kind of have the best financial and revenue objective. So again, kind of going back, the off-taker can get, can negotiate a price that kind of incorporates the fact that they won't, or they can offset their transmission costs. So that is kind of a benefit to the off-taker. And the generation resource not only having a specific off-taker that they can, deliver the energy to. Another benefit of this arrangement is that they can kind of, arrange it in such a way that the off-taker ramps down when prices are really high. This is kind of easiest done with like a data center or something like that, and that's just because the data center can pretty much go down to zero and allow that generation resource to really capture high prices. And when we've seen this work out, there's kind of a price that the off-taker and the generation resource have kind of agreed to as being the price in which, the resource or the off-taker will shut down so that resource can, take advantage of pricing. When we've seen these arrangements done as well, we've seen kind of time limits whereby, kind of this arrangement can only happen, 10 hours during the year or some number like that. And again, it's really coordinating between the off-taker and the resource to really get the best combination of factors. And we've seen that be really attractive to kind of investors because they can, realize actual benefits from the offtake agreement while also realizing benefits of being able to participate in the market at those high prices. So, again, it's a benefit to the generator who locks in the firm customer for their capacity or a portion of their capacity. So one thing that we haven't discussed is, when these arrangements are made, it doesn't have to be for the full capacity of the resource. It can be for a portion of that capacity. And we've seen kind of more interest in doing it for that portion. So again, it goes back to kind of the economics of the project, making sure that that off-taker takes enough of the generation at a specific price to make the project economical, and then the other, megawatts of the project can be sold into the ERCOT market as you generally would see it sold. So this arrangement really leverages a financial partnership Again, this is a hedge against congestion and curtailment risk if it's located near a constrained transmission element by affording the generation that firm off-taker. Again, kind of a benefit of this can be attractive to investors, again, because they can see actual revenues and kind of a project being, making a profit when the congestion might not otherwise have the project fully able to deliver power. And so again, the benefit to the generator is it makes the project appear more cost effective to an investor by adding a revenue stream. And then also kind of, again, with these arrangements, we've seen them done in kind of all sorts of ways that really benefit both participants and can make the generation resource really effective in the system. And that, again, goes back to kind of the discussion that we've had about the resource, kind of the arrangement making it so that the resource can really take advantage of high prices when those prices are actually happening. And one thing to discuss too is that, there's going to need to be coordination between the off-taker and the resource so that the kind of resource knows exactly what the off-taker is taking, can kind of do their own internal modeling, and when those prices, kind of if the arrangement is set up in this way that, there's a trigger for when prices hit the specific point that the off-taker can kind of ramp down their, what they're taking as quickly as possible. And so I think kind of that's going to be the end of our slides. I know we've gotten a lot of questions, and so Chris, I'll loop it back to you.
Yeah, thanks, Maria. Thanks, Landon. Let me go ahead and repeat the solicitation, if you will, for questions. We've had a few questions come in. Before we get to audience questions, I wanted to ask a couple of questions that we had talked about a little bit in advance. So first one is, does a behind-the-meter type of arrangement, does that require the participants to register as a private use network when there's a customer load behind the meter, and that load might be itself registered as a load resource?
So I'll take
I can field that one. Go for it, Maria.
Oh, go ahead, Landon.
So the current understanding right now is that whenever just the co-location of customer load with generation resources or an energy storage resource, when they're behind the same point of interconnection, does not need to be registered as a PUN. At least that's how ERCOT's currently viewing it. Now, PUN, when it's classified, that the PUN classification is actually selected by the resource entity. Now, ERCOT is actually looking at this and trying to figure out what they want to do going forward, because there have been a lot of different scenarios out there, particularly those involving controllable load and other sort of unique things that can happen. So they're looking going forward, kind of seeing what they need to do to make their modeling work going forward. But at this time, there's not a requirement that those be registered.
Okay. Next question wanted to visit with y'all about is just talk a little bit more, just kind of expand a little bit about how to develop the behind-the-meter relationship between an off-taker, so I guess the PUN load, and then the generation resource. What kind of issues typically come up in that?
So I'll take this one. So the issues that we've seen are related to the allocation of risk for a change in policy or any potential ERCOT charges. So while kind of there is an understanding as to what ERCOT charges would be kind of assessed on these arrangements, there is still some risk associated with that. And if the load and the generation aren't related to each other, meaning, have a common parent, something kind of that sort, or even if they have different investors in them, there is, and what we've seen is that there's definitely tension with kind of who bears the risk. Is it going to be, and this would be the regulatory risk, is it the generation resource that, is benefiting from this off-taker that needs to bear some of this risk, or is it the off-taker that bears the risk because they're kind of what I'll call the new kid on the block, meaning that they are, normally we see these arrangements with existing generation, and then now you are putting load behind to take some of that generation. So the question is, if the new entity comes in that is now kind of increasing the inherent risk of just this generator operating, if it's going to now be that load that needs to take on the risk. So we've seen kind of a lot of back and forth. This is especially an issue that's raised by tax equity investors for a project, because those tax equity investors don't want to take on any additional risk, especially if there's a thought that there might be risk associated, again, with ERCOT charges, or just if it's not done correctly, potentially PUC fines, things like that. We've also seen this in kind of the same risk allocation in areas served by cooperatives and munis, and that's basically because cooperatives are very risk averse, so they try to push all, or our experience has been, they try to push all regulatory risk onto the generation facility, and kind of the risk gets pushed to the generation facility because that's who kind of the cooperative mainly interacts with. And so that would be kind of the facility, especially if the kind of excess generation is going to be put onto the ERCOT grid. That's going to be the generation that the cooperative kind of cares the most about. So again, kind of any shift of risk like this becomes a red flag to any investor in a generation facility or kind of for the off-taker, because their kind of inherent desire is to push risk onto the other party. And again, it becomes more complicated in muni and co-op territories because they, as Landon described, they have to participate in this kind of arrangement unless there's an exception kind of granted. And so if they're participating, kind of their incentive is to push all risk off of them. And again, that can even be risk of, the muni having a different classification at ERCOT, or, something that is just not currently contemplated by what you would normally think of as just a general kind of easy behind the meter kind of arrangement.
Yeah, Maria, that's a lot of ground covered there. If I could follow up just briefly on one, point that you kind of were beginning to touch on. Apologies, we haven't particularly discussed this in advance of the presentation, but you got a generator that is serving a load in some respect, and then also is interconnected to the grid and might want to take advantage of pricing opportunities as those come up in the grid. But then you also have a load that wants a steady supply, let's say, or as a hedge against high pricing events. I mean, to make that work, don't you pretty much have to have something akin to like an energy management or more than just the usual PPA that talks about, all right, well, here's when the generator is free to bid out into the market, versus no, even if there's high prices, that the generator is still required to serve the load. Do you typically see that there's that kind of an agreement that is involved in setting these things up, or do people just sort of, how do people address that?
Yeah, so that is actually a really great question. Our experience has been that there might not just be one document that kind of details this arrangement, but multiple documents. So kind of as you pointed to before, if this is not just a straight, my generation is going to this off-taker 100% of the time, not kind of taking into account what's happening in ERCOT, then, the document that you see kind of governing that relationship is a lot simpler. What we've seen, though, is when the generation wants to actually take advantage of higher prices, there are a lot of restrictions around kind of when it can do that. So, one of the major factors that gets negotiated is what price does the ERCOT market have to actually reach for that kind of off-taker to agree to ramp down so that the generator can take advantage of those prices. So that, when we've kind of seen this happen, that's been highly negotiated, and the off-taker has put backstops too on that, meaning, in any given day, the generation resource, can't exceed a certain number of hours, meaning that, the off-taker knows in any given day it might only not have to ramp down for an hour or 2 hours, something like that. And in addition, we've seen, provisions that, not just day provisions, but how many hours in a year the generation resource can take advantage of the higher prices. Kind of going back to what I said, if the generator and the off-taker are related in some way, those provisions can be more relaxed than if they aren't related, meaning, if there's the same parent involved, there's an advantage for the generator to take advantage of the pricing more hours during the day, more times during the day, at a lower ERCOT price, things like that, versus if they aren't affiliated or aren't related, then kind of as you pointed out, the off-taker doesn't want to have to pay high ERCOT prices. So it's kind of, when we've seen this arrangement the most successful, it's been either when the generation and the off-taker are related, or where the off-taker is a type of facility that, is like a data center. It can ramp down to zero, and if ERCOT prices are too high. And so kind of in that arrangement as well, the off-taker can get a better kind of price for its generation, or for the generation it's taking, because it knows that it's providing a benefit to the generation resource, because it will allow the generation resource more times during the day to take advantage of higher ERCOT prices.
Yeah, and I guess if you're developing this kind of from scratch, which I guess we're not really doing as much of that, meaning the load is going in at the same time as the generation, you can kind of plan that out well in advance and come up with all scenarios. But if you're kind of shoehorning in a load behind an existing generator, which is what you said kind of at the outset of the presentation, then I guess there's a lot more to consider, like what's the historical generation been, and what's the load going to be, and who's going to be dominant. Is it going to be just whatever generation capacity might happen to be left over after the load is done with it is what you can sell, but there's a recall. Anyway, I guess there's a lot of issues that come up when these things are being developed that we could spend a lot more time talking about, but we've had a lot of questions come in, so I want to get to those.
Hey, Chris.
Yeah.
I just wanted to add one thing as well. When we've seen these arrangements kind of done, there's also kind of provisions for renegotiating. So if kind of the historic, peak demand of ERCOT, things like that changes, then there are kind of provisions or understandings between the off-taker and the resource that kind of the time that the resource can participate in the ERCOT market might change over time, or the amount, like the megawatts that they deliver to the off-taker might change over time. So there are things like that too that are heavily negotiated kind of at the outset of this, knowing that congestion might change, prices might change, things like that, so that everyone is kind of aware that, this isn't a 20-year PPA or something like that. It's more short-term contracts.
Yeah, and then I guess you talk about like material change in circumstances, and all of a sudden there's 5 different additional loads put in kind of at the same spot, and it screws up your congestion profile. And well, I guess the generators are always going to want to chase the bright, shiny objects of the peak pricing too, and so that's a big consideration. Anyway, okay, sorry about that. So lots of questions have come in. Very grateful for that. So let's try to start working through those while we still have a little bit of time left. The first couple I think, relate to kind of sizing requirements and minimum capacities. So one of the questions is, can you have a pun? Whenever I hear pun, I always think of the O. Henry pun-off, which admittedly is kind of pitiful on my part. But anyway, can you have a pun if the generation is under 10 megawatts, is behind only 1 meter for the industrial facility, so I guess that's a customer meter, and does not provide ancillary services? And then kind of another question, which I'll call up at the same time, are there megawatt thresholds below which the pun concept does not apply? The questioner says, for example, generation net of load at max generation is below some threshold of megawatts. For example, DGR registration requires a minimum of a megawatt to be eligible. So can y'all talk about, kind of sizing requirements?
Sure. As some background, so puns are a transmission concept. So the definition, an electric network connected to the ERCOT transmission grid that contains load that is not directly metered by ERCOT. So it's sort of, for the sizing issue, there's not necessarily a true minimum, but it does have to be connected directly to the transmission grid. Typically, when you're talking about 1 megawatt generation facility or load, they're going to be connected at the distribution level. As for whether or not, imagine a 9.8 megawatt resource that's connected to transmission. It wouldn't be modeled under the ERCOT rules. It wouldn't need to register as a pun, but it would very much be considered a pun under the definition. So the answer to the first question is yes, absolutely. You could have a private use network that had less than 10 megawatts of generation on it. It just wouldn't, ERCOT wouldn't be required to add it to their model.
Okay. I see we had another question that was just basically explain the minimum generation capacity requirements in a pun. Okay, is it possible to install solar plus storage or solar plus an electrolyzer, whatever that is, sounds very Austin Powers-ish, to produce green hydrogen behind the meter with puns, or can you only install the renewable generation without the storage or without the electrolyzer behind the laser under puns? Is anybody able to take a crack at that?
Yeah, so kind of what we've seen is that these arrangements haven't been kind of located with storage. It's, the ones that we've seen so far have been either a wind facility or a solar facility. And really the reason for establishing these puns has been kind of going back to what we've discussed before. At some point during development or, operation of the facility realized it was behind a point of congestion, and so, wasn't really able to kind of make the profits or deliver the energy as it anticipated that it would be able to. And so in those circumstances, the generation resource has thought, kind of what can I do in this scenario? And so has, tried to either approach off-takers or kind of establish this kind of network so that it can, sell power that it wouldn't otherwise necessarily be able to deliver to the ERCOT system. We've had questions about, adding storage in these kind of scenarios so that, the storage can participate in ancillary services, things like that. But really, again, we're still seeing that this is something new that's being developed. And so kind of because it's still in these early stages, it's been really to kind of take advantage of, or kind of, we've seen it be more generator driven so that the generator can kind of make profits behind these points of congestion. But again, I would expect that at some point in the future, as these become more sophisticated, it might be with storage located kind of in the same general unit. Okay.
A couple of transmission-related questions. They aren't really the same question, but they're the subject of transmission. One is, I guess it's kind of a legal question. Why can't the term essential interconnection facilities that a generator is able to own be considered to include the project-owned private power line that goes from the project site to the single point of interconnection at the buyer's facility. So between the generator and the customer. And then the other is who's responsible for the transmission interconnection facilities costs for a PUN, the load, the generator, or the TSP. So I don't know if y'all want to take those in turn.
I can take a stab at that first question. So kind of why it's not considered to be essential interconnecting facilities. Really, kind of this goes back to the question that we had before about allocation of risk. So normally when kind of these arrangements are set up, you know, because essential transmission facilities isn't really defined, it's understood to be certain things, but it's not really defined. What we've seen is anytime there's a suggestion of potentially the generator owning kind of the line that would connect the generator to the off-taker, there really is too much risk associated with that kind of either the generator's investors or the off-taker or the rep involved, kind of one of the various parties kind of bulks at it, and so that quickly comes off the table. And that again goes back to, you know, what is essential. And so kind of the reason that that's not considered to be essential is it's not required for the generator, and it's not essential for the generator to connect to ERCOT. In fact, what's kind of being done is that the generator is connecting to this off-taker so that one of them avoids delivering, or so the generator avoids delivering full capacity to the ERCOT grid, or the off-taker is avoiding taking full power from the ERCOT grid. So that's really why kind of the recommendation has pretty consistently been that it shouldn't be the generator that owns these facilities.
Okay,
So
what about that
if you want to
on the T costs?
Can you repeat that question, Chris? Sorry.
Well, if not, I can take a stab. Who is responsible for transmission interconnection facilities costs for a PUN, load, generation, or TSP?
So I can take part of that from, oh, go ahead, Landon.
I was going to say, I think for part of it, there's different sorts of costs whenever you interconnect something, and some of them will be very much directly related to, the off-taker or the generator. For example, the costs associated with going through the if it was a new generator, then the new generation interconnection checklist, those would all very clearly likely fall on the generator. But I think a lot of it would be negotiable between the parties, the things that are going to be common for both of them. And Maria, I'll let you hop back in.
Yeah, so just to kind of go off of what Landon said, in those instances where the generator kind of is already established, and again, this is kind of where we've seen really recently these agreements come up in this context. If the generator is already established, those kind of interconnection costs would have already been borne by the generator and already paid. And in those instances where kind of the off-taker comes on second, we've seen the off-taker have to take on kind of any costs associated with establishing its portion of the network. Again, kind of it is negotiable in the sense, if you think about it, kind of in the context of, how badly does the generator need an off-taker to kind of be behind the meter. And so again, while the generator might not pay for those costs, because again, just to avoid regulatory risk and kind of going back to that risk allocation, we have seen kind of the idea of the cost be baked into the price that the off-taker pays, meaning the off-taker might pay a lower price for that generation if it's going to have to pay for all of the costs to interconnect.
Yeah, I want to get back to the earlier question about essential interconnection facilities, just one thought in addition to what Maria indicated. I agree it's not a defined term, but I would worry that you might have like a Destech situation. And that's where Destech, Cogen, Lyondell tried to set up a, kind of an early proto-microgrid, if you will, and, built interconnection lines between the Cogen facility and other off-takers. And this is pre-competition, mind you, but the court found that that was conducting electric utility service, that was not necessarily just a privately owned line, partnership, distribution of assets. I would worry that, in light of that kind of precedent, that a court would see the line between the power plant and, kind of the sole customer as not an interconnection facility to the grid, but just a private line that's used to render some sort of electric service, which is really outside the bounds of what generators are supposed to do, especially in our restructured market where there's not supposed to be that kind of relationship. Okay, just me sort of intruding into that. So a couple more questions. We got a few more minutes. This is kind of an interesting question. Can ERCOT determine you are not a pun if you meet the letter of the rule definition? ERCOT can kind of do whatever ERCOT wants to do. We're attorneys and tend to think that if, the protocols kind of are expressly supportive of it, then, ERCOT can't really violate those. It could find that the facts aren't consistent with the definition of the rule, but under your question, if it meets the definition that's in the rule, then it would be classified as a pun. So I would count that as no, or else ADR time. Another kind of interesting question, can you explain the difference between a behind-the-meter generator that is part of a pun as distinct from behind-the-meter generation that is not part of a pun? When do y'all want to take that?
Yeah, I can take that. So really kind of going back to the description that Landon gave, if a pun is kind of an ERCOT created term, so what we've seen is, a behind the meter generation kind of that would, generally be considered kind of in a pun, and I'll say pun behind quotes, is different than one that meets the definition of a pun. So what kind of I've seen is, kind of a behind the meter generation resource that doesn't deliver, to the off taker above 10 megawatts, then, or doesn't participate in ancillary services, things like that, then that's technically not considered to be an ERCOT defined pun. And additionally, I've seen kind of behind the meter generation that's not part of an ERCOT defined pun when the off-taker isn't even connected to the ERCOT grid. So that's something that we haven't really discussed, but we've seen arrangements, especially in the context of the generator wanting to take advantage of high ERCOT prices in kind of muni territory, and then also like to add a layer of complication where the load would actually be part of SPP and not ERCOT. So in that instance, the load was not connected to the ERCOT grid, and so it was strictly behind the meter, and because of the way it was arranged, it did not meet the ERCOT definition of a pun.
Isn't the biggest difference that you just don't get the generation netting? I mean, if you're, same exact setup, but you're not in a declared pun.
So kind of going back to what I was saying, in the context where it was not in an ERCOT defined pun, they still got the generation netting aspect of it, but that was because the off-taker was not connected to the grid. So basically the off-taker took the power from the generator, kind of siphoned it off, and then the excess generator power went to the ERCOT grid. So kind of from ERCOT's perspective, you know, that wasn't a pun. And again, the load wasn't even connected to ERCOT. So it, again, added a layer of complication onto it.
Right, but if it's the normal case where the customer is an ERCOT customer, then you wouldn't get the netting.
Yeah.
Okay. Okay, one last question, and then let's call it a day. If more than one load customer is served by a PUN, can it still avoid classification, and I guess it would be the generator? Can it still avoid classification and regulation as a utility by a single customer's ownership or control of the PUN's distribution network? So I guess that's if you've got two customers and one of the customers owns the wires, is that cool? I don't know if one of y'all want to jump in. Or if I phrased it wrong, if you want to resubmit it, that's fine too. But anyway, go ahead.
You know, I think one of the challenges with that will be looking at the actual definition, and I think that it's in some ways a bit unclear because there's not an exception under the definition for electric utility for a customer. So I would be concerned, but I don't think that it's necessarily a very clear answer one way or the other. There would be a couple ways to address that, you know, vagueness, which might take a while. You could file for a declaratory order with the PUC. But I think that there's a bit of vagueness there in how the rules, or uncertainty really, in how the statute and the rule are written. Chris or Maria, do you have any thoughts on that?
Yeah, I was just going to add that kind of a lot of these questions go back to, you know, one of the first questions we discussed, which are what are the risks and what kind of the allocation of risks. When this question has kind of been presented to us in the past, the risks kind of outweighed any potential benefits. And so, you know, in discussions, it ended up being kind of what I'll call the safer bet for each customer to own their own kind of what I'll call interconnecting facilities, so that it looked more like something that would be permissible and something that, you know, ERCOT has seen, investors have seen, you know, generators have seen, things like that, to kind of avoid any, you know, any ambiguity, and again, to make it so that you don't have an even bigger risk allocation, or risk allocation risk, so to speak, because again, that risk allocation ends up becoming something that is really negotiated heavily, and just kind of avoiding as many risks as possible has been a key driver in creating these networks.
Yeah, I agree. I think if they sort of, what's the right term? If they sort of parcel out ownership so that it's not a single owner, but each one kind of owns the pieces that serve them, that probably works. If it's just, and if this isn't what the questioner had in mind, then apologies. But if it's simply one customer owns all the wires, and those wires serve not only the one customer who owns it, but another customer, that's starting to look like utility service. But I think there's also the Flint Hills example. So in Flint Hills, my recollection is the two customers sort of jointly owned all those distribution lines, or the distribution facility. It was like a 50-50 deal, and they kind of both contributed to the O&M and the operation. And there, I think the commission said that is not providing utility service. That's not the hypothetical that's in the question, but that is a way that two customers could participate in kind of one behind-the-meter collection of distribution lines. Okay, we're over time. So we're going to call this, call a halt to all this fun. And there's still a couple of questions we didn't get to. We'll try to answer those offline. So thanks everybody for joining. As a reminder, we've been approved for continuing legal education hours. So if you want to report that, there's the CEU icon at the bottom of your screen, and we'll send a certificate of attendance to you by email along with a recording. And again, really are hopeful you can answer our survey because we use those for future programs. So thanks everybody for your time. Look forward to visiting with you soon. And thanks again. All right, take care. Bye.